morning, Justice of the Supreme Court. My name is John Goldpaw. I have the pleasure and honor of representing Police Officer Nevin Hughes in this particular matter. Ms. Stidlak will be representing Officer Little, and Mr. Fishman will be representing, Officer Harris. We are also representing the amicus briefs by the Police Officers Labor Council, as well as the Police Officers Labor Council and the Police Officers Association of Michigan, who have filed amicus briefs in this.
Do you all intend to make arguments?
Yes, we do, Your Honor.
You've divided your time then?
Yes, we will, Your Honor. I will divide
Up
my
to you to
time.
manage it.
I will set down the facets for this. Ms. Stidlak.
As long as you manage your time, that's fine.
Thank you very much, Your Honor. Your Honor, the first thing that must be addressed in this particular matter are the settings in which the defendant's statements were given. In this particular matter, Officer Hughes was working with Officer Little and Officer Harris. This was in November of 2009. They made a traffic stop or an investigation of a Mr. Lamar, and during that investigation, Mr. Lamar was ticketed and released. Mr. Lamar went to the hospital, claimed he'd been injured by Officer.
I'm sorry, maybe you didn't hear me. We've actually read your briefs.
I understand, Your Honor.
All right. Unless these facts are really critical to the legal question here, I urge you to get to why, in your case, we should be reversing the Court of Appeals.
And I understand, Your Honor. And they are critical.
Okay.
Because it must be pointed out that the investigation and the Garrity statements were not given to an investigative agency investigating criminal activity. The statements and the complaint that was filed, and I put this forth in the brief, was filed with the Office of the Chief Investigator. The Office of the Chief Investigator is an investigative body for the Detroit Board of Police Commissioners. The investigative body is charged with not investigating criminal matters, but is charged with investigating alleged violations of the rules and regulations of the Detroit Police Department, including, but not limited to, excessive use of force. In this matter, a complaint was filed with that investigative body. An investigation was conducted. Officer Hughes was informed he was the focus of an internal investigation. He was then given his Garrity rights, as well as informed that anything he said could not be used against him criminally, could not be used as a springboard for criminal evidence, but could be used against him departmentally. Could also be used against him if he made a knowing false statement. He could be disciplined for that. He could not be charged criminally for that. Subsequently, Officers Harris and Officer Little were also given those same warnings, but they were informed they were not the focus of the investigation. It is under that premise, under that setting, that the Garrity statements were given. Subsequently, Officer Little was charged departmentally. That matter was dismissed when a hearing was scheduled. Officers Little and Officer Harris were not charged. It was at that point in time that Internal Affairs, through the professional standards, determined that they were now going to bring, or at least investigate, criminal allegations against Officer Hughes. During that investigation, Officer Hughes was called in. He was not given his Garrity rights. He was, however, provided with Miranda. He exercised his Miranda rights and refused to make a statement. Officer Harris and Officer Little were brought in as witnesses with respect to the underlying misconduct of Officer Hughes. Officer Little and Officer Harris were again given their Garrity rights, signed all the appropriate forms, as they had done with the internal discipline investigation by the Office of the Chief Investigator. Unlike the original investigation, a video had surfaced. This video was shown to Officers Harris and Little to refresh their memories as to what had occurred 2 or 3.5 years previous. When they were shown those interviews, they then made Garrity's protected statements as to what had occurred back 2.5 years ago. Those Garrity statements were submitted as part of a warrant request against Officer Hughes. Only Officer Hughes was charged with respect to the warrant request to the Wayne County Prosecutor's Office. And there is no mention whatsoever in the warrant request of any violations of Garrity. There are no mentions of any inappropriate statements. There are no mentions of the underlying Garrity statements that we are now before this court. Rather, they do mention the Garrity statements of Officers Hughes and Little made to Internal Affairs, not made to them.
You must think I hadn't read what you wrote.
I understand, Your Honor.
No, you don't.
Oh.
Because you keep talking about facts. I want you to get to the law.
We are at that point.
Good.
We get to the point where the investigation under the statute clearly protects internal investigation. The statute we are addressing deals with statements that are required to be made as part of an internal investigation. Had they taken Officer Hughes and as the focus in the criminal investigation, he would not have been given his Garrity rights. He would have been given, as he was in this case, Miranda. The Court of Appeals notes that any reasonable defendant should have known that they could have been charged with future statements, such as misconduct in office, from the original Garrity interview, back for the Office of Chief Investigator. That's inaccurate, because they were told at that point in time that they were not there for a criminal investigation. They were told...
What difference does that make, whether they were told that they were or not subject to a future criminal prosecution?
Because...
Why is that relevant to whether these statements are protected by the statute or not?
Because, Your Honor, these statements and the statute particularly address internal investigations.
All right.
Therefore, since it's dealing with internal disciplinary administration,
Yes.
they cannot take this gigantic leap and say, oh, and by the way, we're promising you that we are not going to charge you criminally, but this is only to be used...
Look, whether they get prosecuted criminally could be entirely independent of these so-called Garrity statements. The video itself is independent evidence of police conduct, is it not?
I agree, Your
All
Honor.
right, so I don't understand what your point is. I'm really trying to get you to explain to me why this statute was improperly applied by the Court of Appeals.
Because, Your Honor, where it was applied and obtained from. If the court would, as I've indicated, we are going to divide this argument up, and I would, at least at this point in time, allow Ms. Sidlak to address the issues, if that would be acceptable. Thank you very much,
If she's
Your
going to talk about law, that would be good.
Honor. No,
Good time
that's,
to
I
go.
understand, Your Honor, thank you.
Good.
Good morning, Pamela Sidlak on behalf of Detroit Police Officer William Little. But I am going to address the statutory issue that we were asked to brief
That's
with
good,
respect to all three appellants' defendants. And I'm not sure if we said we did want to reserve 5 minutes for rebuttal.
You got to manage your own time.
Okay.
Good.
The court asks us to address whether 15391 precludes the use of false statements by a law enforcement officer in a prosecution for obstruction of justice. Our answer quite simply is yes. It precludes the use of all involuntary statements by law enforcement. So whether the statement was true or false, or if the police officer went in there and just babbled, 15.391 protects the statement that was made. In the prosecutor's brief, it indicates, I call it a bit of a red herring. The important part of the statute in this case is the beginning of the sentence, which reads, "An involuntary statement made by a law enforcement officer shall not be used against the law enforcement officer in a criminal proceeding." The important part of the statute, and you'll notice I did delete the information part, is an involuntary statement by a law enforcement officer. And that's exactly what we have in this case. All three statements, I don't think there's any dispute, were coerced, they were required to make them, and they cannot be used in a criminal proceeding. The reason we have this statute, and Exhibits G and H that are attached to the prosecutor's brief, does have analysis on the bill, although it says we don't want you to consider this legislative history. It does have extensive analysis on the bill. The reason this was enacted in 2006 is the result of a 2003 case in Ray Morton. In Ray Morton, in that case, the Wayne County Prosecutor's Office issued an investigative subpoena to get Garrity statements from the Garden City Police Department on statements that officers had made with regard to a murder. A challenge was made by the Garden City Police Department to the subpoena. They didn't want to turn it over. And the Court of Appeals addressed only the limited issue in that case on whether it could be turned over. They did decide that it could be turned over. But one of the things that they do note in that opinion, while it's very short, is we're only addressing whether the information should be turned over. We're not addressing whether it could be used in a criminal proceeding against the officer. And they also imply in that opinion that it would be wrong to do so. The Court of Appeals panel, in this case,
So Garrity would have made that inappropriate, right? Garrity itself.
Garrity itself.
Okay.
So what the legislature did in this case, or in enacting the statute, is in response to the Morton decision, they didn't like that it was being turned over, so they enacted 15.391 and the subsections that we're dealing with today.
So we're supposed to assume that the legislature passed the statute it did in response to this Court of Appeals opinion from 3 years before, and therefore meant to immunize lies, even when, at the same time, by the time the statute was enacted, those statements plainly did not enjoy protection under the constitutional protections that Garrity extended to the context of threats from removal from office. Why wouldn't I assume the legislature was acting with that, principle in mind, instead of worrying about this 2003 Court of Appeals case?
Because the analysis on the bill and on the legislation indicates that this is in response to In re Morton, but it does say we want to codify Garrity, and Garrity in and of itself, Justice, stands for the proposition that statements made by law enforcement officers shall be protected, shall not be produced.
Unless they're lies.
Unless they're lies.
Garrity itself does not say that.
But
It's
the jurisprudence of SCOTUS since then,
Right,
for 20 years before this statute was enacted,
absolutely.
had made it clear, right?
30.
30, sorry, I'm sorry, I can't count. 30 years, it said, it was clear as a matter of federal jurisprudence that if you made a Garrity statement and you lied, you were vulnerable. It did, the protection afforded by Garrity did not extend to lies made as a Garrity statement, correct?
Absolutely correct, and
Well,
that is under the
then goes-
federal,
That now, we pivot now to the question asked by Justice McCormick.
Just helping you.
Well, thank you. I was having a moment here. So why wouldn't, if it's codification, why isn't the Garrity exception for lies part of this statute?
that's something that we really need to go to the legislature for, because in this statute, it only speaks to if the involuntary statement is coerced. It does not, and the legislature certainly knew of Garrity, all the case law that followed, but they chose, they didn't qualify it, they didn't modify it, and they've done so in so many different type of statutes that we have. We have the perjury statute, the immunity statute, the health care law statute, and in fact, only our criminal sentencing guidelines, they have the modifiers and the qualifiers. Inaccurate information, or if it's knowingly false statement truthful testimony only is protected under the immunity
Your
statute.
argument then is, this isn't a codification, this is an expansion of Garrity.
No. This is a codification of Garrity in its purest form. It was the progeny of Garrity that held false statements are not protected. And the legislature could have easily put that in, Justice, when they enacted this statute. It would take
Your view
adding-
is Garrity, as informed by the later Supreme Court decisions, does not include an exception for lying?
I'm not sure I understand your question. Can you?
If
Garrity,
we say Garrity, we don't just mean the original opinion.
Right.
We mean it as the Supreme Court has subsequently interpreted, correct?
correct.
So by the time this statute came along, Garrity, the bundle of rights that were afforded by Garrity, the Garrity doctrine, was you are protected unless you lie. So my question to you, which you had difficulty with, is your position isn't that this statute codifies Garrity, but expanded Garrity. Because Garrity, understood 30 years later, did not include protection for lying. You're claiming the statute does.
The statute itself, the way it was written, is broader than Garrity. And in fact, the Court of Appeals panel, the majority in this case acknowledges that, and In re Morton acknowledges that, I'm sorry, not In re Morton. In re Morton acknowledges that it cannot be used in a criminal proceeding. But it is in the majority opinion in this case at the Court of Appeals level that this is a broader statute. And if the legislature, knowing that the legislature does know of Garrity and all the cases that follow, if they meant to exclude false statements, it could have and should have been added.
But why
But they
wouldn't we
didn't.
make the opposite inference? Since the pre-existing law already failed to immunize false statements, when the legislature goes to codify Garrity and its progeny, why don't we assume that they also intended not to immunize false statements?
Because we have to be a strict constructionist. We have to read the words when it makes sense and it's unambiguous, and there's no really clarification to be made, because it is clear. An involuntary statement made by a law enforcement officer is protected. It cannot be produced. And in fact, in this case, the prosecutor's office should never have had it. It wasn't produced as a result of a subpoena or an investigative subpoena or a court order. It's being used as the sole basis for the obstruction of justice charge. It is information, and it's being used in a criminal proceeding, all of those things being against the statute.
You need us to agree with you that exculpatory lies can be, or are in this case, involuntary or compelled, right? And can you point to any other statutory contexts that have reached this same interpretive conclusion? Why should we assume that an exculpatory lie can be or is involuntary and compelled?
Truth is compelled,
Right.
but lies, why are they compelled?
It's, what we're looking at is the statement in and of itself. That's compelled. We may not like that the result, that this statute, the way it's written, does protect false statements and truthful statements, but that's the way the legislature wrote it. They didn't, and they most certainly could have, as they did in the immunity and perjury statute, said, except for inaccurate or false statements. This protection is afforded to the police officers except for false or inaccurate statements, and they've done it over and over and over again.
But are there
and
any
they
other
haven't.
contexts where they have specifically immunized exculpatory lies? Has the legislature done this anywhere else?
Not that I'm aware of.
And so why here? Can you tell me? Why'd they do it here if they never did it anywhere else? They don't immunize exculpatory lies, but now they do or did in 2006. Why?
I think when you read Exhibits G and H of the prosecutor's brief, I think that provides the answer. That there was outrage because of In re Morton, that the officer's statements were being produced. But even
Well,
in
that's
that
a simple
case,
fix. You just say by
Don't produce them.
statute, you can't produce them. Something more than that
well,
seems to
they
have
do
happened.
that
I
with the
know.
statute.
That would've been the fix for Morton. Very simple. Can't produce them as a matter of statutory.
Right, but with, the legislature instead went in depth and has the numerous and the various provisions that, to address the problem that they found in re Morton. The heart of the matter is, the beginning of it, of the statute indicates an involuntary statement shall not be used against a law enforcement officer. It's simple reading, it's plain, it's unambiguous, and we're asking that you find that language in and of itself, even though we might not like the end result, that language protects the statements in this case. And I know that Mr. Fishman wants to address the Detroit,
He was about to knock
Forms.
you over.
Yeah,
I know, I felt it.
there was a little activity on that side of the road.
I think she heard the bat swishing. But let me try to answer, before I start on the third part, let me try to answer some of the questions about, particularly about this immunizing thing. I don't think that's what we're saying. We're not saying they're immunized. What that statute says is,
Oh, counsel, my big assignment, can you state your name for the record?
Oh, I forgot.
I
Steve
know,
Fishman.
it's my big assignment today.
Okay.
Correct,
Yeah,
guys.
he's the keeper of the record.
Yes.
Steve Fishman, it's my first appearance here in only 42 years doing this. Generally, I'm in front of juries, as you instructed the last guy, don't talk like it's a jury, so I'm going to try not to do that.
Fine.
We're not talking about immunizing anything. What we're talking about in the statute, and Judge Wilder's dissent, which I quoted from liberally, as you all know, really says it perfectly. It's not a matter of trying to confer immunity on anybody. It's the question as to whether or not the statements can be used in a criminal proceeding, pure and simple. Immunity is not an issue we're discussing. We say, and I'm,
Six of one, half dozen of the other, Mr. Fishman. Come on, tell me why would they immunize lies?
I don't think it's 6 of one, half dozen of the other. I'm not going to spend much time on it, but I honestly believe that what they're saying is, I think it's clear. If they wanted to say that false statements are not included, they could have put it in there. And they're not immunizing. They're just saying you
Well,
They're
can't.
saying you can't be
excluding. Okay.
I mean,
Use another synonym.
yeah, they can't be used in a criminal prosecution.
That's it. Precisely.
Okay,
Okay,
why?
we can say
Okay.
it that way.
Yeah,
So
we'll say
now
your
let's
way.
jump, to
Yeah.
let's jump to the next thing, which is my assignment. And that is the reservation of rights form, and whether or not.
No, you jumped,
Without answering.
Without
We're willing
answering.
to use your
but go ahead.
phrase.
They exclude.
They say they can't, yes, they exclude it. They can't be
Okay.
used against, I just.
Why? That's the question.
That's a
Why would they do that in
question,
this context and nowhere else?
that is a question that we have to address to the legislature. The legislature wrote the statute, and I could read, I wrote it down when Justice Larson took office. I read something in the paper and I wrote it down, something that you said. I believe in,
It's against me.
That's not
you don't have immunity.
But I
Here's what you said, in the newspaper, of course, which is always problematic. I believe in enforcing the laws as written by the legislature and signed by the governor. I don't think judges are a policymaking branch of government. That's all we're asking you to do with respect to this statute.
See, that's what you get for
Read what it says. Read what it says. It was signed by the governor and apply it.
Right, but we're trying to figure out what it says. So, an involuntary statement, in what sense is the statement involuntary? So it might be involuntary if you drag the truth out of me and the truth incriminates me. But isn't it voluntary if I go there and I choose to lie?
No, I'll tell you, I'm gonna tell you straight up, okay? You're focusing on the wrong thing in terms of involuntary. Involuntary means those police officers never would have said a word but for Gary, but for being forced to talk. That's what involuntary means. To distinguish it whether it's truth or lie means nothing. It was involuntary because they had to do it or lose their
They're
job.
put at a table and they say, if you don't talk to us, you lose your job.
Luca Brasi, right, either your brains or your signature will be on this contract, or on this table, whatever it was from The Godfather. Yes,
You know, quoting The Godfather is very persuasive with me.
well, I didn't do any research, as long as I've known you, I should have known that. But in any event, that's the answer. About involuntary means that's why they were making a statement. It doesn't have anything to do with dragging anything out of anybody, okay?
But
So-
the word involuntary aside, just focusing on the word information, the word they do use, this is used in a context in which there's a trade-off, there's a quid pro quo. So even if you look at it on the basis of some kind of, bastardized contract theory, what is it exactly that the government's getting for its quid pro quo here? The government is providing something of benefit to the police officer, and what are they getting in return?
They're getting, now you're into the argument that Mr. McCready made and that Mr. Woodford came as a spectator made to begin with, this business about information versus misinformation. If you all accept their discussion that, contrary to what I think the dictionary says, contrary to what Judge Wilder thought, that somehow when you speak, if it's not 100% true, then it's not information, then we're going to lose. If you guys go off on that and say, hey, it's misinformation, it's not protected, to me, that's...
Isn't it information simply by virtue of the fact that it can be verified and it advances the investigation in that regard, even if it proves to be incriminating to the person who gave the statement?
It could be. To me, information is, I ask you a question, you give me information. Whether it's true or false, it's still information. It might be false information, but I don't see anything in the statute that says it's only true information, or if it's not true, it's not even information, which is what they're saying.
You haven't had much time as your colleagues, but you're under 5 minutes, so if you want to reserve.
Well, I'm going to do it real quick then.
That's fine.
Because the third issue is, to me, controlling for this court. And that's the one that you asked us to brief. And so what do we have? We have the rights form. And what does the rights form say? It says to them it's solely for administrative purposes, solely for administrative purposes. And it says clearly it cannot be used against you in a criminal case. So what do we have there? Is that a contract? I say it's a contract. What do I say to support that? In addition to the wording, I gave you the case of McKinley versus Ohio. I'm not here to tell you you're bound by what an Ohio appellate court
Do you
did.
need to prevail on the statements in order to ultimately succeed in reversing the Court of Appeals here?
Do I need to prevail on the...
Our construction of what these statements mean.
I think with respect to this third issue, no, it doesn't matter what it means, because I think...
The statute is sufficient.
I think it's sufficient. And I just want to take a minute to distinguish Gallego, which was cited. That was a Supreme Court case many years ago. I was a young lawyer at the time, and the guy got talked into giving up where the drugs were and the money was. It wasn't the drugs. And they made a deal with him, kind of an ad hoc quid pro quo, just with a couple of agents. There was no prosecutor involved, blah, blah, blah. Supreme Court eventually upheld the conviction, but what they didn't do was they didn't allow the evidence that came out from essentially statements that were coerced. And the differences between Gallego, the holding was the same. The statements were going to be suppressed, which is all we're asking for here. But there was no contract. And this is a contract between the Detroit Police Officers Association and the department. This isn't some ad hoc, we sit down and I want some information out of you, so I'll make you a promise I have no authority to make. So this
But that
case,
wouldn't be binding on a prosecutor, would it?
I'm sorry?
That wouldn't be binding on a prosecutor, would it?
It would not, and that's what Gallego said. But
Yeah.
we're, again, Justice, excuse me, we're not saying that they are entitled to immunity. This is all about whether the statements are admissible. Now, there's a stipulation back from the district court that the statements are the only basis of the case. That's true. But we're not asking for immunity. We say the statements should be suppressed, just like McKinley. The McKinley case is almost identical. The reservation of rights is the same, and the ruling is the same as what Judge Wilder said in his dissent. I'm not saying it's great public policy. I wish the legislature would change it. I wish the Detroit Police Department would change it and change their reservation of rights form. But as things stood for these officers, A, they were coerced. B, the statements were involuntary. C, there was a contract as to the third issue, and therefore, it seems to me, that's it. Whether it's information, misinformation, or whatever phrase that the prosecutor wants to use, I hope I saved a minute. If I
You
did,
just have
that'd be
done
great. Okay, thanks.
That's 16.
Good morning, Your Honors. May it please the court, Dave McCready for the people. If Officer Hughes had walked into this Garrity interview and he had said, if you don't drop this, I'm going to do to you and your whole family what I did to Mr. Lamar. According to the defendants, that would be inadmissible in an extortion case because it was the information that was involuntarily given. The same with Officers Harris and Little. If they'd come in and said, look, we'll give you $10,000 if you drop this. Again, that bribery would not be admissible in a bribery case, and it can't be. It's not information in those two cases, and it's not information in this case because it's an independent crime is what's happening here. It's an independent crime of obstruction of justice. And just as We could have prosecuted a bribery statement or an extortionary statement. We can prosecute in an obstruction of justice. And I would invite questions from the court at any time.
Tell me about the case of United States versus Applebaum, interpreting a federal immunity statute that made no distinction between information and misinformation, truthful or untruthful. Doesn't that really undermine your position?
Not at all. Applebaum had to do with something altogether different. It had to do with whether once a witness who's been given immunity perjures himself, whether it's only the perjured testimony, only the false testimony that can be admitted in the subsequent perjury trial, or whether they can also admit the true information that was testified to. And the Applebaum court said, once you've violated your immunity agreement, you've testified falsely, everything comes in. And that's what the immunity statute talks about, the federal immunity statute. So that when the court says that there's an exception in the federal immunity statute that says that you can't use the testimony or other information except in a prosecution for perjury, giving a false statement, or otherwise failing to comply with the order, that's where it doesn't matter whether it's truthful or untruthful. In the exception, they're not talking about when the Applebaum talks about the federal immunity statute not making a distinction between truthful and untruthful, it's not talking about the testimony, it's talking about the exception. So therefore, in Applebaum, the Supreme Court said, it all comes in, the truthful and untruthful information, because you violated your immunity agreement.
Opposing counsel seem to have some difficulty with this concept, but it has been sort of bruited about in the briefing that this statute represented a codification of Garrity. It seems to me that it is a great deal more than a mere codification of Garrity. Would you agree with that?
In certain respects, yes.
In what ways is it broader, would you say, than Garrity itself?
Well, the point that counsel has made in terms of In re Morton, Garrity has nothing to do with whether the statements can be divulged to the media or whatever. Number two, there is an open question under Garrity what constitutes coercion in a Garrity statement. In other words, does it have to be, you gotta be threatened with dismissal, or can be some lesser employment sanction? And this codification that we have broadened it to say, or at least clarified that to say any employment sanction.
Right.
Those are the two, but the underlying protection is exactly the same, and if you look at the legislative history, that's exactly what it says.
What do we do, counsel, with the fact that in so many other contexts, on multiple occasions, and specifically in the immunity context, the legislature specifically has modified the term information with the term truthful? I didn't see this in the dissent, I didn't see it in the defendant's briefing, but it troubles me that in many other contexts, many other statutes, the legislature does modify information with truthful when that's what it means.
Well, I would say two things, Justice McCormick. The statutes that I'm familiar with, they say truthful, they say truthful testimony. And I think that's different because
I have like 20 of them that say truthful information, even in the immunity context.
well, there's certainly, the legislature has said things like false information, misleading information, and so the question is whether that's a subset of information or whether that's a separate set altogether. And, you know, that's a linguistic question that I think
But
the
it's a
key
signal.
is,
It's an important linguistic signal about what the scope of the protected communication is. And what is startlingly absent here is an indication that perjury or lying, if it isn't sworn, is not protected. And in this context, you'd especially expect, since it's not an immunity as such, but it is functioning pretty much in the same way as immunity does. It's a suppression of otherwise relevant information about potential crimes. So one would kind of expect the legislature, if they were concerned about insulating from or protecting lying in this context, they would have said truthful information or something like that, wouldn't you think?
well, but they also could have said an involuntary statement means anything said at the Garrity interview, or
Pretty
it means
much they
information
did.
or misinformation. So
Pretty much it means information provided. And the only way you prevail is if we say that information cannot include false information.
And I'm gonna say, in the context of this.
Isn't that right? I mean, you
Correct.
cannot win unless we construe information in the definitional section as excluding false information.
That's correct. That's correct. And I would say that here is the contextual argument going right to this statute, because in section 3, it says that information derived from the statement can't be used. And the word information has to be used consistently within the same statute. And information in section 3 only can be truthful information. You
No,
can't
it can't be.
derive.
No, wait a minute. The fact that somebody lies to me is something that I can determine, possibly, is in fact false. If I'm doing an investigation and I'm interrogating a witness and they say the light was green, in fact it was red, I can talk to other people and say, I was told the light was green, was it? And they say, heck no, it was red. So I have gotten false information, but it does lead me in a meaningful way to be able to investigate whether the information was
In a
right or
strange
not.
way, it's useful misinformation.
Right.
Because it advances the search for truth.
Well, to the extent the information is false, there is no information that's derived from it. I mean, if you, in the immunity context, when you are given immunity for your testimony, the police can still charge you for the crime that you've testified that you committed. But if they can't use the information derived from it.
Doesn't it get to you said I mean, there's a couple issues under the statute. There's not just one issue, right? It could be the case that information includes false information or lies, but the immunity only extends to the criminal charge that's being investigated. So you have to also look at the scope of the immunity in the sense of which potential charges are covered, right? So I mean, we have to talk at least for a moment about the meaning of a criminal proceeding. And there's a third issue that Justice McCormick mentioned earlier. That's whether you are coerced when you're providing false information, whether that's involuntary or a voluntary act. So there's a couple of other issues that we have to address, I think, before we're convinced as to how to construe the statute.
Well, except that, I agree, Your Honor, the involuntary statement is defined. I mean, that's my whole argument, is that in section 1, it reads, involuntary statement, quote unquote, means information. So, and then under the context of threat of dismissal or any other employment sanction. So it is an involuntary statement if it's information.
What about the question that Justice Viviano asked, that there's a framing question about the criminal proceeding? Does the criminal proceeding have any particular limiting aspect that allows us to determine anything of value here?
Well, this legislature could have said the criminal proceeding, a criminal proceeding, or any criminal proceeding. I don't think it could have said the criminal proceeding, because this is not, a Garrity interview
The
is not a criminal
context is
proceeding.
not a criminal proceeding.
Exactly.
It's an investigation.
So then we're between the difference, a criminal proceeding or any criminal proceeding.
Basically, the reference to a subsequent criminal proceeding is the protection, is how the protection is supplied. You cannot use, for lack of a better word, these Garrity statements in any subsequent criminal proceeding. Is that what that says?
Yes, that's how I read it.
Mr. McCready, in a 1999 decision of this court, one that, to the best of my recollection, has not been cited by either side, the McIntyre case, the court indicated that a statutory requirement that one answer a question in a criminal immunity context cannot be construed as requiring that one answer a question truthfully. Why would providing information be assumed to have implicit a requirement of truthfulness any more than providing an answer to a question?
Because if truthfulness is not required, then there's no reason to do these interviews whatsoever. At the very least, it's implied because...
That's not answering my question. I understand your answer in the abstract, but I'm comparing it to a decision of this court in which we have said that a defendant or an individual, a witness who is providing some information in an immunity context may answer questions, and even if his or her answers are false, they nonetheless continue to entitle that individual to immunity.
If I'm understanding your Honor correctly, you're saying that this court has held that under our immunity statute, that if someone perjures themselves, they can't be prosecuted for perjury?
Perhaps they can be prosecuted for perjury, but they're still entitled to immunity in the context of that particular immunity statute, yes.
Well, we could not use their statements against them. Officer Hughes,
Well,
for example.
I'm not interested in getting in the issue of immunity. I'm interested in getting into the issue of why an answer to a question does not contain any implicit requirement of truthfulness, so why should supplying information in response to a question contain such an implicit requirement?
It's implicit here because that's the whole purpose of a Garrity interview it's a quid pro quo, as Your Honor mentioned.
Well, the whole purpose of an immunity interview is to get presumably truthful information too, and the court said that no, that's not always going to be something that's going to be an essential requirement to granting immunity in response to an individual who answers questions, whether or not those answers are truthful.
And is, in that case, was the word information being construed? I mean, that would be the difference that I would see, is that here it comes down to what is information. The legislature used the word information, and
Can
Okay.
can I ask a question about information? So what if the officer made a statement that was false, but he didn't know it to be false? So, I don't know, he reports what happened at the time, he's wrong, but not deliberately wrong. So he's not lying, but his information is not truthful, because it's not accurate. What do we do with that statement?
well, you wouldn't be prosecuted for that, first of all, because
Well, the matter of discretion of the prosecutor probably isn't a great deal of
Doesn't help.
relief.
well, I mean, you look at the Garrity cases, it's not, this has not come up in terms of police officers being prosecuted for what
Well,
are mistakes.
if we go with your construction, it matters, because you guys have discretion then to say, well, it was untruthful, it's not protected under the statute, we're gonna prosecute you.
The Court of Appeals opinion, at least, would allow you to prosecute somebody who gives
Inaccurate.
what they think is truthful information, but is inaccurate. So is that something we should be concerned about? It even seems to contravene the purpose of the statute, right?
Correct. So, and in my brief, what I had said that.
Is prosecutorial discretion the only thing that stands between your interpretation and a prosecution for giving misinformation, inaccurate information?
Well, there's the preliminary exam when the judge can, dismiss our case for lack of probable cause if it's clear that this was just a misstatement rather than a deliberate lie.
But counsel, doesn't that go to why the legislation was drafted and put into law to prevent that type of a situation, to allow for the free flowing of information? And, I mean, ultimately, no one here is happy with the results, but doesn't that go to the key cornerstone of why this legislation was put forth and the wording the legislature used?
Well, if that were the case, then bribery and extortion would be protected too in this context. And that just can't be. So if they come in and commit an independent crime, the statute here is to protect the free flow of information so that when an officer comes in, they're not subject to criminal prosecution when they admit, yeah, I saw something wrong or I did something wrong. That's what the statute is about, to try to counter police misconduct, to try to rectify it. If this court rules that lies are immunized, it's going to be the opposite. It's going to be that police are going to be encouraged to lie.
But going to Justice Larson's comment, the concept of, I think that what we would like to have a better understanding of is that distinction between a mistake and a lie. I'm just saying, maybe no one's happy with the outcome here, but isn't that the reason the legislature possibly wrote it this way? was to address what Justice Larson was saying.
Two answers. One, I'm not aware of a single case where that was an issue, that we had not charged somebody, I'm talking about Wayne County, I'm talking about prosecutors nationwide, that we had prosecuted someone for a mistaken statement rather than outright lie. But second part
That's a
is,
discretionary thing.
second point is, in my brief, I would agree that a misstatement, a mistake is not covered, is covered in the statute. In other words, information, if you distill the definition of information, is it's true from the point of view of the speaker.
Wait a minute, how do I get, involuntary statement means information true from the perspective of the speaker.
Well, if you look at what the definition, I mean, information is not defined here in the statute, so what does information mean? If you look at the
I don't
dictionary
even know where I
definition-
find that definition just sort of generically. If I looked in a dictionary, would I find that?
I think that if you looked in a dictionary and you looked at what information is, generally
Counsel,
speaking, it's from the perspective
isn't
of the
this whole
speaker.
conversation what the legislature was concerned about? In
Yes,
terms of why they might have drafted using the language they did?
well, you're right, and if you go back and look at the legislative history, there's nothing whatsoever about immunizing lies in police cover-ups. It's all about codifying the basic right, which we know does not immunize lies, and
No, you could say that what they were trying to do was not necessarily, we've been using immunization because it's kind of a proxy, but what they're doing is creating a suppression. If you talk to us under threat of employment sanction, your statements will be suppressed in any criminal proceeding. That's pretty straightforward issue.
yes, but in the context of Garrity itself, Garrity provides no protection, and it's the legislature could have said,
My question is, you would have expected, after 30 years of Garrity and its progeny, where it was quite clear that your statements that were truthful would be suppressed, but your lies would not, you kind of expect, if that's what they were trying to do here in the legislature, that's kind of what they would have expressed, wouldn't it?
well, the question is, did they express that? I mean, if they meant to immunize lies or exclude lies, they could have said, involuntary statement means anything said by a law enforcement officer if compelled under a threat of employment sanction. Anything said at all, right? That would be clear. I mean, information, unfortunately, is not perfectly clear one way or the other, but
But
then
it's
you
more
look to
clear
the...
when you look at all the other immunity statutes and other criminal statutes where they modify it with truthful. I mean, do you have any other examples of where the legislature has used the term information in isolation while clearly meaning truthful information?
Well, I say in this statute, because I disagree
I know,
that...
but besides this one, I'm just trying to look, because there are all these others where they modify it with truthful, and that's hanging me up.
This has the aspect of a unicorn, where it's singular, as opposed to the common herd, where when the legislature doesn't want to protect falsity, they say it. But here's this pretty little thing here that's unadorned by any limitation that excludes expressly false statements.
I agree that it could be clearer, but that doesn't answer the question. I mean, the fact that it could be clear doesn't tell us for sure, one way or the other, what is it that it actually means what they did say. And information implies veracity.
Well,
From the point of the speaker, I agree that...
Doesn't it also imply that as a result, there's a function of the information, one becomes in some way more informed, more enlightened, more aware of reality, rather than being just, being in just the opposite situation, being instupidated, being made less aware of reality, being less cognizant of what existence is.
Steve, that sounds like my whole life.
So,
I mean, is it really that ambiguous when
gonna
you
be in
talk
the
to
transcript.
99 people out of 100 on the street and you ask them, what is the value of learning information or having information coming to your light? Wouldn't they tend to answer somewhere somewhere along the lines, it makes us better informed, it makes us more aware of things, it makes us more learned in some way. It doesn't take away those virtues from us, does it?
Exactly, and the investigators here, when the officers came in and said nothing happened, they were less informed, not more informed. Right, the officers came in here, and the information they provide is that nothing happened, that this complaint is false. That was not information from the point of view of the speaker or the listener.
Counsel, what about omission?
I'm sorry?
How would you deal with omission? Because what I'm trying to understand here is there's an extreme that you have to always look to. You know, what about if information was omitted? You know, then it comes down to discretion, doesn't it?
Well, I would say no, because, this is an obstruction of justice.
Right?
So unless.
But what if someone doesn't share the whole story, they share part of the story? They
Well,
omit things.
These are responses to questions. They're being told that your information can't be used against you in a criminal proceeding. So the quid pro quo is, we gotta get to the bottom of this allegation.
But
So if they're asking questions and they're not.
But this, I think, is my concern. Again, and I go back to this, the distinction between a mistake and a lie. If the legislature codified the information the way they did, do you think it could be stated that the legislature did so because they were taking it away from your discretion? That they didn't want this to be a discretionary call? I'm not saying I agree or disagree with the outcome. I mean, no one's happy, again, with the results of this. We're just looking to the legislative intent. And the question I have is, do you think that the legislature drafted this in such a way that they were worried about the fact that it did go back to discretion?
Well, as a prosecutor, I can charge anybody with anything. I mean, I have just about unlimited discretion.
But
So-
isn't that maybe why the legislature then drafted the language the way they did, because of the answer you just gave?
Right, but you would think if that were the case, that there would be some history of misuse of that discretion in this kind of situation. And there's been none pointed to by the defense, and there's none that I'm aware of. There's none on the record. So all of a sudden, the legislature comes around and fixes a problem that no one's even raising. It doesn't make sense. It doesn't make sense that they would try to, in the context of trying to get to the bottom of police misconduct, create a mechanism where officers are encouraged to cover it up. If they were going to do that, they should have eliminated the procedure
Maybe the
altogether.
proponents of this so-called codification really were concerned. They didn't want to have the disputes about whether the statements were fully disclosing or partially disclosing or even false. Maybe they just wanted to take that issue off the table. I can imagine a few police officers might want to do that. And I assume they were the proponents of this change, wouldn't you think?
Absolutely. I think this is very pro-police,
Okay.
right? So,
Yeah.
right, the legislature is free to do something that is poor public policy. This court isn't there to be the super legislature.
And my question therefore is, why isn't this entirely consonant with the desire not to have police officers put in a pick of maybe misstating or lying or anything else? It's, if you put them through an internal police investigation, whatever they tell you, it's off the table. And why isn't this language entirely consonant with that objective?
Because it would undermine the purpose of the statute. You should get rid of Garrett
If the
interviews
statute
altogether.
is intended to provide a nuanced distinction between fact, fiction, lies, and truth, true. But if the goal is just to take all of these communications off the table, period, and prevent them, suppress them from being introduced in subsequent criminal prosecutions, why isn't that congruent?
Because there would be no reason to even bring the officer in. Why would an officer tell the truth if this court says that the law of Michigan is that you're encouraged to lie? Why would any officer tell the truth?
But
Right,
is
they're
that
a
what-
witness.
But counsel, is that what it's really saying? Is
That
it
is
really saying
exactly
you're
what the court
encouraged?
would say.
But is it really saying that you're encouraged to lie? Or is it really saying that you're encouraged to come and speak freely, whether you make a mistake or not? I mean, again, the outcome here is separate from what the legislative intent was. I mean, I mean, again, we're trying to focus on, was the intent maybe to allow people to come and express themselves and not worry, oh my God, was the light red, was the light green, was the light yellow? I don't want to get caught up in a lie even though I'm making a mistake. I mean, maybe that was the intent. Again, it can reach results that we're not happy with, but we're looking to what the intent of the legislature was, and what I'm trying to get to is, couldn't that have been the intent?
No, that couldn't have been the intent, because what you would say is, if you overrule the Court of Appeals, is that officers who come in have no incentive to tell the truth.
Can I
Because-
ask a question? Is there any internal police discipline that could happen to these people if they go into the room and they lie?
Yes.
So my incentive is I'd like to keep my job.
Yes, but if I admit to misconduct, which is worse? Them finding out later down the road
Well,
about
sure.
my lie?
So, of course, for the people who commit big crimes. But
Well, that's
maybe
what
what
we're-
about the people who commit little infractions?
And
They
they're
might
fr-
be able to keep their job.
And their first choice is to say nothing at all, but they're being put in a position to give us a statement or you're fired.
Correct.
So following up with that supplement, answered Justice Larson's question.
Right, so, yes, they have to talk, because the whole point of this is to get to the bottom of allegations of police misconduct. If you have someone come in who's alleged to have done something wrong, their incentive is to lie. And what you would be saying is, that's correct. Now, I
Or the
understand
legislature.
understand that there may be an employment sanction, but my point is that that's down the road if they find out that I've lied. My whole point in find out, because if they do, I'm liable for both now.
All right, a few moments ago, you answered the Chief Justice's question by saying it would undermine the purpose of the statute. When I was done with this case, reading the briefs, the record, all the memos from my clerks, the memos from my colleagues, I was left with this. The dissent seems to be based upon the specific language of the statute, and the majority bases its opinion on the intent of the legislature. This is what they really meant. Would you agree with my assessment there?
No, because the majority looked at the word information and said they agreed with our analysis that what the officers gave was not information. I mean, it was a statutory analysis based on the word information.
All right.
I mean, that's
If
what
you
it
don't,
turns
don't
out.
agree with my premise, then I won't go further.
Well,
There you go.
I mean, I'm certainly willing to answer the question, but the
Sufficient.
first indication, as this court has said multiple times, of a statute is the plain language of the statute. So it comes down to what is meant by information. And
Right, and that takes us back to Justice McCormick's point that the legislature is pretty clear when they want truthful information, what to say. So if you want to go down the plain language road, I think that when they use the word information without modifying it, without giving us any further indication, they're referencing any information that can advance this proceeding, even if it's untruthful information,
Well, I
or
mean-
inaccurate information, or just a misstatement.
I mean, this court has recognized in some situations the legislature uses a belt and suspenders approach, right, where they say, they reiterate where it doesn't necessarily need to be. And I'm not familiar with all the other statutes. I just know that in this statute, information in Section 3 especially, I mean, that's kind of the key here. When you look at information in Section 3, you can't derive evidence from false information. You can disprove what someone tells you, but that's not deriving from that information. You can only derive from truthful information.
Well, one can look to the purpose of a statute in order to try to infer some meaning as to the statute. That's a legitimate approach to statutory interpretation. If you assume that this statute is designed to be of some benefit both to police officers who find themselves in this circumstance and to the government, which finds itself in this circumstance, and if we accept the arguments of the other side, what conceivable benefit would there be to the government?
There would be none. Right, so, I mean, as I was saying, the
I mean, there would be
legislature-
none. I would emphasize that if that's your argument. There would be none. There would be no benefit left, because not only would there be lying allowed in this context, but whatever decision emerges from this court in support of that would almost certainly further incentivize and communicate that that would be within the rights of the police officer in complying with this investigation, right?
That's absolutely my argument, Your Honor, and that point informs the definition of the word inform in this context, that it would not make sense for the defense definition of the word information to apply, because it would gut the statute altogether. It would make it superfluous.
There'd be no quid pro quo left, as you've
Exactly.
indicated.
Exactly. So I would just ask this court not to find that police are encouraged to cover up their own misconduct, but rather they are required to tell the truth at a Garrity interview. Thank you.
Thank you very much. You have a minute. Minute and 16 seconds.
16 seconds.
The first thing I want to say is that now I see the difference between going to Oak Park High School and Mumford. The word "instupidated" never once was in our curriculum. I want you guys to know that.
You can start this time.
All right, now,
Yeah, it is.
really quick, I want to make sure I've addressed both Justice Larson and Justice McCormick's point about coercion and involuntary. We're talking involuntary, meaning they're policemen. They wouldn't have to say a word, as Justice Zara said. They're forced to say something if they want to keep their job. That's what I mean when I say the statement's coerced, or when I say the statement's involuntary. That's what I mean. Secondly, and this might take less than a minute, I want you all to look, because I just did while I was listening to Mr. McCready. When you look at the actual statute we're talking about, 15.393, here's what it says. It says, which provides that, quote, an involuntary statement made by a law enforcement officer. Let's stop right there. Then there's a comma. It says, and any information derived therefrom or derived from that involuntary statement shall not be used against a law enforcement officer. Let's get rid of the middle phrase. An involuntary statement made by a law enforcement officer shall not be used against a law enforcement officer. This case, by stipulation, the entire case is based on an involuntary statement made by a law enforcement officer. The second part of it, whether we debate information, misinformation, non-information, that's just another clause. The initial statement is the involuntary statement cannot be used against that officer in a criminal proceeding. That's what happened here. So
But
even
the
I would
question,
suggest,
though, the definition of what an involuntary statement, according to opposing counsel, means information. And it is being argued, Court of Appeals majority bought it, that information does not include within its ambit lies.
true, agreed.
You agree that that's what it says, but you don't agree with that construction of information.
No, I do not agree with the construction of information. I think we've gone over about that back and forth.
Was your client compelled to lie?
No, my client was compelled to make a statement, and that's coercion, and it was an involuntary statement. No, of course not. Nobody's compelled to lie or tell the truth. I mean, you say you're going to, but doesn't mean you're necessarily going to.
Before you leave, I was tempted to quote newspaper statements that you've made as well, but decided not to. You referenced Justice Larson's comments. in the paper.
You're going to quote.
We
from
looked
me.
up
Right,
some of
right,
yours.
Yeah.
Yeah, turnabout is fair play. I just
I
wanted to
think I
warn
know
you
what
for
you're talking about,
future,
too, but
future.
I heard the buzzer go, so let me go sit down.
Thank you very much. Case is submitted.
Thank you.
Don't come back for another 42 years.
All right.